Today's docket update from DOA, or Scott Hochstetter versus ZeroDarkTony or Anthony D'Amato, is a masterclass in how not to practice law. ZDT's lawyer Stephen Tamer is at the center of the story. While DOA was not awarded a permanent restraining order, he was successful in defending against an important motion filed against him. First, let's go back to May 27th. That's when Judge Melanie Ochoa denied Anthony D'Amato Jr.'s motion for attorney's fees. The clerk sent out the ruling and the minute order was posted. Under California law, that started the 60-day clock for an appeal. That made the deadline July 28, 2025. Simple, clear, final. But then came Stephen Tamer. On August 4th, long after the deadline had already expired, he filed a notice of entry of judgment or order. Now, this is something the winning side usually files to lock in deadlines and prove service. But here's the catch. Tamer lost. He was serving his own defeat. And worse, his notice didn't even include the order he was supposedly serving. Imagine sending someone an empty box and calling it a gift. 1 week later, on August 11th, he tried again. This time, he stapled on the actual May 27th ruling, as if to say, "Oops, here's what I meant the first time." But by then, the appeal deadline had been dead and buried for 2 weeks. Filing it again did not bring it back to life. Normally, filing a notice of entry can be strategic. If you win, you serve it to make sure the other side cannot drag their feet. You control the clock and you close the door on appeals. But here, filing it only highlighted that Tamer lost. He was not protecting his client. He was broadcasting his own failure. First in defective form, then in duplicate form. It's like losing a race and demanding the announcer replay the footage twice on the stadium jumbotron. So let's pause right here. Legal analysts, what do we make of this? Why would a lawyer file not one but 2 pointless notices of entry after the court already served the ruling? Was Tamer confused? Was he trying to restart the appeal clock? Was this just boilerplate filing on autopilot? Or maybe a desperate attempt to control the narrative in the docket to make it look like he was taking charge, even though he was just stapling his own loss to the public record? Here is the reality. The appeal deadline expired on July 28th. The August 4th filing was defective. No order was attached. The August 11th filing corrected that defect, but by then, the deadline was gone. So what exactly was his game plan here? And let's not forget the bigger picture. How does this fit into Anthony D'Amato's scam strategy? It fits perfectly, because even pointless filings can serve his grift. They create the illusion of activity. On the docket, it looks like his lawyer is still fighting. They confuse deadlines. Later, he can claim the clock started in August, not May, even though the law is clear it did not. They pad his online narrative. He can say, "See, we're still in court, it's not over." They keep donations flowing by pretending the battle continues. And they intimidate opponents with the appearance of endless litigation. But legally, it's hollow. The deadlines are done, the ruling is final. These filings don't change that. All they do is feed Anthony's performance, using the court system like a stage prop. And let me be clear before we continue. I am not a lawyer. I don't practice law. I don't have a license to practice law. Nothing I am saying here is legal advice. This is commentary, observation, and critique. For legal conclusions, we leave that to the professionals. And now, let's turn to the order itself. The ruling Tamer worked so hard to reserve. The May 27th minute order. The one where Judge Ochoa carefully dismantled his fee request and denied it outright. Let's read it. This matter is Hochstetter versus D'Amato, case number 2024 STRO 08472, heard in the Superior Court of California, County of Los Angeles Division. The Honorable Melanie Ochoa presiding, with N. Young as Judicial Assistant and Aldo Napoles as Court Services Assistant. The ruling was issued on May 27th, 2025 at 8:30 a.m. The court notes that no appearances were made. The matter was not called for hearing and was handled outside the presence of a court reporter. On February 7th, 2025, the parties, along with Respondent's Counsel, appeared in Department 13 for a hearing. The parties provided a time estimate of 2 to 3 hours for the hearing. Due to court congestion in Department 13, the matter was therefore transferred, for purposes of that hearing only, to Department S in the Pasadena courthouse. Department S considered petitioner's request for a restraining order and found that petitioner did not sustain the applicable burden of proof. The court denied the petition, dissolved the temporary restraining order, and ordered the matter dismissed. Respondent filed a motion for attorney's fees on March 10, 2025, as the prevailing party in this case pursuant to Code of Civil Procedure, Section 527.6, Subdivision S. This motion was heard on April 25, 2025, in Department 13 and taken under submission. Section 527.6, Subdivision S, provides that, quote, the prevailing party in an action brought pursuant to this section may be awarded court costs and attorney's fees, if any, end quote. The determination whether to award attorney's fees is within the discretion of the trial court. In Wash v. Banda Wash, decided in 2025 108 Cal App 5th, page 561, at page 568, the court explained, quote, the legislature's use of the word may plainly indicates the issues of whether to award any fees, and if awarded, the amount recovered are committed to the trial court's discretion, end quote. Compare with Krug v. Maschmeyer, decided in 2009 172 Cal App 4th, page 796, at page 802, where the court stated, quote, the decision whether to award attorney fees to a prevailing party, plaintiff, or defendant under Section 527.6, Subdivision S, is a matter committed to the discretion of the trial court, end quote. A prevailing party generally includes a defendant in whose favor a dismissal is entered, as set out in Section 1032, Subdivision A, Paragraph 4. Respondent is the prevailing party under Section 527.6, Subdivision S, and this court may use its discretion to award fees. In exercising that discretion, the court may only award fees that are reasonable, and the burden of establishing reasonableness is on the party seeking fees. In Gonzalez v. Santa Clara County Department of Social Services, decided in 2017 9 Cal App 5th, page 162 at page 169, the court stated, quote, in determining a fee's reasonableness, the court may also consider whether the motion itself is reasonable, both in terms of the amount of fees requested and the credibility of the supporting evidence. End quote. See also Gillory v. Hild in 2019 36 Cal App 5th, page 802 at page 811. The amount of fees requested by counsel is $18,528.75 for a total of 27.45 hours expended at a rate of $675 per hour. Respondent's counsel claims entitlement to that rate based on having practiced law for more than 32 years. Counsel did not provide any evidence to support a claim that respondent was obligated to pay counsel for the stated hours at a rate of $675 per hour, or any portion thereof. In fact, counsel did not even claim that his requested fees were actually incurred by respondent. When the court asked counsel whether he charged his client that amount, or could produce any bills or documents to reflect that the amount requested was actually incurred, counsel expressly refused to do so, claiming that doing so would potentially violate attorney-client privilege. When the court asked counsel whether he appeared pro bono on respondent's behalf, counsel again refused to answer on the basis of attorney-client privilege. Instead, counsel argues that he is entitled to the rate of $675 per hour because he contends it is a reasonable amount, not because it reflects an amount actually incurred by respondent in this case. Counsel also did not provide any comparable rates for attorneys in this practice area, nor did counsel identify any prior fee award received at this requested rate for his services. This refusal or inability to support the requested rate is particularly relevant given petitioner's evidence in opposition to the fee motion that counsel operates a website where he advertises his legal services in landlord-tenant matters at a rate of $375 per hour, slightly over half of the rate requested here. For example, counsel is requesting $5,400 for 8 hours of court on February 7th, including travel time and time waiting in court. On his website, he advertises his services at $675 for a full day in court. The request for $5,400 is therefore more than 6 times the advertised rate. In fact, the requested rate of $675 per hour in this case is equivalent to counsel's publicly advertised full-day rate. Counsel also advertises his services at $1,295 for judge trial preparation. Yet in this matter, he billed 5.2 hours explicitly as trial preparation, totaling $3,510. He also billed 10.75 hours the same month for reviewing trial materials and preparing witness and exhibit lists, generating at least $7,256 for work that would generally be considered trial preparation in a case such as this, which has no pre-hearing discovery or motion practice. When asked about the basis for the difference between the advertised rates and the rates sought here, counsel stated only that these were different types of cases and that restraining order matters are more complex without further substantive explanation. Petitioner also challenged the number of hours spent on several tasks. Among them is a time entry dated February 3, 2025, in which counsel claimed 2.1 hours to review an exhibit list from petitioner, which consisted of only 21 minutes of video footage. Petitioner also challenges the validity of an entry of 6.4 hours billed on February 1 to review videos and research without further description, and an additional 5.2 hours billed on February 6 to prepare for trial. There is limited case law applying Section 527.6, Subdivision S, and neither party has identified any case in which a court has decided whether a prevailing party under this provision is limited to fees actually incurred or entitled to any amount that might be deemed reasonable. Some attorney fee provisions unambiguously limit fees to the amount incurred. For example, in an inverse condemnation proceeding, a prevailing plaintiff may recover reasonable attorney, appraisal, and engineering fees actually incurred. Code of Civil Procedure, Section 1036. Applying that statute, the Court of Appeal held that where a prevailing petitioner did not introduce evidence at trial to establish the amount of attorney's fees she was obligated to pay, the trial court did not err in denying the request, no matter how reasonable such an award might seem in the abstract. That was Andre v. City of West Sacramento, decided in 2001-92, Cal App 4th, page 532 through page 536. This court interprets the language of Section 527.6, Subdivision S, as imposing a similar requirement that fees actually be incurred in order to be recovered under this provision. The statute authorizes recovery of court costs and attorney's fees, if any. The phrase "if any" indicates an intent to permit recovery only of fees that are actually incurred, not merely hypothetical amounts. To incur a fee is to become liable for it. It is not enough that the amount requested might be considered reasonable in the abstract. The court finds that respondents' inability to establish that any of the fees requested were actually incurred in this matter prevents an award of fees under the plain language of the statute. In addition, to the extent the court may have discretion to award fees, the court declines to exercise its discretion in this case. While not a requirement for imposing fees, the court does not find that petitioner's restraining order request was frivolous. See Krug 172 Cal App 4th, pages 802 to 803. Moreover, given the significant and unexplained difference between counsel's requested rates and the rates for legal services advertised on his professional website, the court finds that it would be appropriate fees even if they were otherwise permissible. In Serrano v. Unruh, decided in 1982, 32 Cal 3rd, page 621 at page 635, the California Supreme Court explained, quote, "A fee request that appears unreasonably inflated is a special circumstance permitting the trial court to reduce the award or deny one altogether. If the court were required to award a reasonable fee when an outrageously unreasonable one has been asked for, claimants would be encouraged to make unreasonable demands, knowing that the only unfavorable consequence of such misconduct would be reduction of their fee to what they should have asked for in the first place. To discourage such greed, a severer reaction is needful," end quote. Accordingly, respondent's motion for attorney's fees is denied. All right, folks, Judge Ochoa made it clear, you can't just inflate your numbers and expect the system to play along. When you ask for outrageous fees without proof, you don't just lose, you get called out. We will see what comes next after this most recent filing. Will Tamer and ZeroDarkTony attempt to keep the grift going? Or will the courts finally shut the door on this endless cycle of legal stunts? Time will tell. In the meantime, thank you for watching. If you found this breakdown useful, hit the like button and subscribe. That way you won't miss the next chapter in this ongoing saga.